think we'll get started. Just want to remind everybody that all of these sessions that we do, they're all interactive, the ones that I do and Jeff does and Frank does. So please feel free to ask your questions because this is what this is about. So make sure that, don't feel that there's a question you're uncomfortable asking, just ask it. And we'll do our best to give you the right answer and the best guidance. Okay. All right. So this is a continuation of the contract mastery series that I started. We look at all different facets of the as-is contract. On the next session, we're going to be talking about risk of loss, force majeure, and some other things. But today we're going to take a look at some of those things that, not that they're overlooked, but we don't really talk about very much. So we shall get started. Okay, why is this not? Let me see what's happening here with my screen. Okay. Can you all see that? Let's see.
I can see it.
Yes.
Okay. Now let me just get back to where I want to go. Okay. I also want to be able to see you, and I can't do that right now. Okay, now I can see you, so let's see what I can do to.
You might need to change your view there. Ruth, if you go to gallery, if you go up to the little squares at the top and select gallery and then open your share window.
Okay. What will we do without you, Frank?
Probably a lot better.
I doubt it very much. Okay. Now, can everybody see it? Yes?
Yes.
Yes.
You're good. You're good.
Okay. So, all right. So we're going to look at those things, like I said, that we don't talk a lot about, but they're there. And usually when we start talking about them, it's because we run across some sort of a problem or we're not really sure what it means. So that's what we're going to do today. We're going to look at those things that are there, but don't get a lot of attention. So I welcome all comments and questions and so on. So that's what we're going to do today. Okay, so what are we really going to look at? So what are those things that can become really problematic? Well, it's exactly understanding these provisions in the contract, being able to discuss them with your buyers and your sellers. That's what's going to set you apart. Okay, this is what the difference is with experienced agents. Okay, because experienced agents understand every piece of this contract, what it means, how it works, and what the ramifications can be. So we're going to take a look at all of these. And in the weeks to come, we're going to move away from the as-is residential contract. We're going to start to move into the vacant land contract and ultimately into the commercial contract. Okay. All right. So what are the things we're going to look at? One of my personal favorites is personal property. And we'll talk a little bit about that. Calculation of time, as-is maintenance requirement. We're going to talk about surveys, permits in a little different way, flood zones, the energy brochure, lead-based paint, FIRPTA 1031 exchange, material defects, walkthrough inspections, which can be problematic, and then professional advice and broker liability, making sure you don't go outside of your lane, that you stay within the parameters of your license. Access to property, which just came up this week. We had a little bit of an issue with that. And then the waiver clause. Nobody ever looks at the waiver clause. It's like a sentence and a half. Nobody ever looks at it, but you need to understand it and what the ramifications of that item might be. So, okay. What's the definition of personal property? Well, in the Florida contract, Personal property is any item that is not permanently attached to the property and can be removed without damage to the real estate. Okay. How does that differ from a fixture? Okay. Very simply, personal property is movable. A fixture is not. It's attached to the dwelling and is considered part of real property. Okay. Okay. So this is the clause that's actually in the contract. It's on the first page. And it goes into a description of what personal property is. All right. It is owned by the seller and existing on the property as of the date of the initial offer. Okay. So I want to make sure that there's a clear understanding of what you see in the MLS. Okay. So you shouldn't be writing into the contract property as seen or as depicted in the MLS. No, it's what was in the property at the date of the initial offer. Okay. Now, some people will write into the contract existing at the date of the showing on, March 20th or whatever it is. That's okay too, but you can't say as shown in the MLS because property is on the MLS for a period of time, right? It can be on the MLS for a very long time. So, and things change. So you can't hold the seller to what they've seen or what the buyer has seen in the MLS. You can't do that. So it has to be the date of the initial offer. Okay. So what are we talking about? We're talking about ranges and ovens. That covers microwaves, refrigerators, dishwashers, disposals, ceiling fans, light fixtures, drapery rods, and so on. Okay. Garage door openers, thermostats, doorbells. Now, does that mean a Ring doorbell? I don't know. We'll talk about that in a little bit. Okay, the storm shutters, storm protection, that was added a couple of years ago. But what is the thing that is missing in here when we look at this definition? What is the most common item or items that are missing?
Washer and dryer.
Washer and dryer. Yep.
Absolutely. So washer and dryer, if that is going to be conveyed with the property, you have to write it in here. Okay. You also should have it specified in the listing agreement. So there's no confusion because you've got some very expensive washers and dryers now, right? So if they're conveying with the property, you have to be specific here. Okay. Other things that go in here are what? Furniture, right? Okay. And we've talked a lot about how that has to be handled. If it's a financed deal, you have to be very careful about how you handle the furniture because it can affect the appraisal.
No,
Appraisal.
she'll come get it. You're welcome. We'll see.
Lynn, you want to mute? Okay. So how do you handle furniture?
I put it on a separate addendum if it's going to be financed.
Right. Okay. Do you get an inventory list?
Yes, I do. Usually during the inspection period.
When you have it on the addendum, do you identify the addendum as like addendum 1 or 2 or something like that to the contract? Or do you write the addendum without any identification?
I write it without identification on the contract. I just call it addendum number inventory to be included, or or furniture.
Okay. How do other people handle it? Anybody else want to tell me how they handle furniture?
Would you take pictures? Because if you just say, okay, the couch goes with, the listing, and then, it's a different couch when the buyer, buys the property. I mean, would you want pictures? You want it like extremely descriptive? I would imagine.
Most people don't go to that detail, Dana. Most of them just
Okay.
have a list. And it depends on what we're talking about. If you're talking about a whole house full of furniture, or you're just talking about, a couch and 2 end tables. But Jeff, what do you think about pictures?
Yeah, so I think it's important to know that it's these items that are in the property at the time it goes under contract. So we've had situations before where people have, swapped a really expensive mattress for a cheap mattress. It's thrown everything sideways. I've had people
Right.
before that have tried to change the refrigerator, or change it good washer and dryer for bad washer and dryer. So I think as descriptive as you want to get
Yeah.
is great, as long as
Okay.
they both agree on it and have initialed each page of whatever it is and signed off that, hey, this is what I'm buying, right?
Mhm. Well, I would imagine
Within
because
the
vacation
inspection
rentals, like if
plan.
something breaks, they're going to replace it. And if somebody didn't do their due diligence, right, and the offer was made and say it takes them 30 days to close, but something has to be replaced, like it should be.
So that's also covered. So it's called the ongoing maintenance and repair. So if something
Yep.
breaks after it's contracted and before it's closed, the seller needs to replace it with a like item.
Right.
It's got to be a like item, not a lesser item or a greater item, a like item.
Like we're going to be talking about the maintenance requirement in the contract, but Jeff is absolutely right. Now, sometimes, Dana, it's easier to do an exclusion list. If you're talking about an entire house full of furniture, which happens with us a lot, but maybe it's easier to do what's excluded from the inventory. But you have to be specific, and the buyer and seller both have to sign off on it.
Gotcha.
Okay. If it's a cash deal, you can write it right in here, and it can be an addendum to the contract unless there's an appraisal contingency as part of the contract.
Gotcha. Okay.
Okay. It's the appraisal that will be impacted by furniture. Okay.
And just for the record, that unnumbered addendum idea was based on advice we got from our brokerage counsel on how to deal with that. So we didn't come up with that unnumbered addendum thing. That was advised us by our attorney.
Okay.
And the reason that it's not identified, let's say, as addendum 1 to the contract, because all addendums have to go where?
To the lender.
To the lender. Exactly. Okay. So what would happen is if you made it addendum 1 and you discussed furniture, and then you had to issue addendum number 2 and 3, which dealt with something in the contract, you can't skip number 1 going to the lender. They're going to come back and they're going to say, where's addendum number 1? So that's why we keep it out of identification. You can write in where it says addendum number, you can just say furnishings and just make it an agreement between the two parties and keep it out of the contract. Okay. Okay.
I have a question. So in Ohio, washers and dryers you just take with you to your new home. Is that how it is in Florida? Unless you write it in, so Florida, you automatically leave it?
Most cases it's left. Yeah. Most cases it is left. All right.
Okay,
But
but it wasn't written in that list before.
right.
You just have to add it in.
You have to add it in because what happens is a lot of people put into the MLS, washer and dryer. Now, the MLS is actually just an advertisement. It's not a contractual agreement, but it's a representation. So if we're silent on that, it can cause problems sometimes. All right. People assume that that's going to transfer. It's going to convey with the property. I've had at least 3 examples where the agents didn't pay attention to it, didn't write it into the contract, and ended up buying washers and dryers.
Okay.
Okay. So you want to write it into the contract itself.
Okay.
Okay. So taking a look at what constitutes personal property. Well, we just talked about furniture. So it includes artwork, televisions, rugs, freestanding appliances, if not built in, personal items. And then you have the other category of things that are not personal property. Those are the things that are fixed. So it's light fixtures, built-in appliances, attached mirrors. That seems to have been an issue of late. Ceiling fans, installed cabinets, and then we just talked about washers and dryers. And this, of course, when we get to the walkthrough, when we talk about that in a little bit, making sure that you understand from the beginning what is included in this property, what was there on the day of the initial offer. So when we get to the walkthrough, we make sure that the walkthrough, when we go through it, everything that was agreed to in the contract is there. Okay. Because I can't tell you how many times walkthrough happens and something's missing, and it can be something very small that nobody paid attention to. I mean, I had it with a statue of a rooster years ago that almost killed a deal. Okay, so. Okay, but there's a gray area now. So anything that you're not sure about, okay, you want to put it in writing. So today you have more sophisticated sound systems and speakers, and you have TV mounts, you have Ring doorbells, cameras, smart thermostats, all kinds of other things that today exist in smart homes and things like that. So you have to be very careful about anything that is going to stay or leave. Okay, that falls into these categories. It's kind of the gray area today. So you got to be really careful about those things that have, especially smart home features, which you're seeing more and more of every day. So when in doubt, put it in writing. Okay. Automatic red flags for you. The seller is taking it, but it's attached to the wall. Okay, or something like that. So you really have to understand and make the seller understand what the contract says. Okay. MLS says it's included, but the contract is silent on something. So if the MLS says it's included, you need to explore that with the seller. Is it included, not included? If there's some concern, then you got to make sure it's in the contract. Okay. Buyer assumes that something is staying. How many times have we had that? With the buyer just assumed that whatever the item wasn't going to leave the property. Well, you can't allow that. That's why you have to be definitive on what you do here. Things that were recently installed or sentimental items. Make sure that you have a clear understanding. Everybody understands, there's a lot of sentiment attached to a lot of things. I know in my house, I feel that way about a lot of things. I'm sure you do too, but you got to make sure it's a sentimental item, but is it staying with the property? Does it have to stay with the property because it's attached? What is the situation with that? All right. So what's the best practice? Use clear contract addendum wording. Okay. Something like all wall mounted brackets shall convey television excluded. Something like that. Smart home devices, including doorbell and cameras, shall remain. So just be careful. Okay. Walk through room by room. Ask the seller, what are you taking, especially when you're taking the listing. Look for anything that's mounted, wired, or bolted. Verify the MLS versus the contract. Make sure you have consistency and make sure all gray items are in writing. Okay. Okay, I can't tell you how many deals. Frank, how many deals have been problematic because this wasn't clear?
I can tell you beyond the shadow of a doubt that it happens way more often than you might think. I've had everything from a problem with there was one where we had a blanket. There was a switched out blanket, and that caused the problem. To walking in, and I'm going to go back and just say when you said about as per the MLS or as was in the MLS. So you're looking at those photos in the MLS, and I walked into a house one time. And everything that wasn't specifically entered in the MLS, like that wasn't in the photo, was gone. I'm talking molding, baseboards, toilets. I mean, if it wasn't in the photo, it was gone. I kid you not. I was like, I can't tell you. So yeah.
Can I ask a question? You mentioned the wall-mounted brackets shall convey televisions excluded. I mean, I guess that's just gray, like where you think, oh, this is an attached item, like your cabinets are attached. It actually maybe isn't. I mean, someone would take the television and leave the bracket.
Yeah. Oh, yeah. Mm-hmm.
Okay.
You always, when in doubt, put it in writing. That's the best thing that we can tell you. When in doubt, make sure your seller understands, though, what, things are attached. They're not supposed to be leaving the property. Okay. But again, you have a lot today with these smart homes. It's a little different than it was before. But also, too, in a lot of the homes that we have, you have some very expensive artwork. That can be a problem. So you have to really, you're dealing with a lot of luxury homes with a lot of very valuable items in them. and you have to be very careful. We had one about 2 years ago, beautiful home, $40,000 in new Tommy Bahama furniture. Beautiful, okay? The buyer declines a walkthrough. Doesn't need a walkthrough. They close, they get to the house. The Tommy Bahama furniture is gone, like Jeff said, and it's been replaced with furniture. Yes, there is a dining room table now with 6 chairs, but it's not Tommy Bahama and it's not the new Tommy Bahama. Okay, but the contract didn't say too much about it either. So we were at fault as well. But talk about a problem. Okay. So you got to be.
That's another thing that I was going to say. I do use brand names. So, because like if they have a Sub-Zero refrigerator in there and then all of a sudden, you don't say Sub-Zero refrigerator in the kitchen or, double-sided Sub-Zero refrigerator, then, they can replace it with something else.
Okay. Okay. Questions about any of this? Okay. Just be careful with it. That's all I can tell you. Okay. The other thing that I get a lot of conversation about, and this comes up over and over again, is about calculation of time within the contract. So the contract is calendar days. It's not business days. All right. And it's calendar days based on where the property is located, which will be used in computing time periods. Okay, so what does that really mean? What that really means is you have to make sure if your buyer is sitting in a different time zone, okay, if they're in a central time zone or somewhere else, that they have to understand that when you set a deadline, okay, let's say, because remember, a lot of these things expire at 11:59 p.m. unless you change it. Okay, it's in Eastern Daylight Time or Eastern Standard Time. Okay, so they may not realize that they're sitting in a different time zone, an hour behind us or 3 hours behind us, and they're not realizing that it's 5 o'clock and you've set a 5 o'clock deadline because they're sitting there and it's 2 o'clock. All right, so you have to make sure that your whoever you're working with understands that if they're if they're in a different time zone. Okay, so other than the time for acceptance, there are two exceptions to what we're going to talk about here. Time for acceptance of an offer and effective date of a contract. Okay. So any time periods provided for dates specified in this contract, and we don't have to, whether pre-printed and so on, which will end or occur on a Saturday, Sunday, or national legal public holiday, or a day on which a national legal public holiday is observed, because it fell on a Saturday or Sunday, shall extend to the next calendar day, which is not a Saturday, Sunday, or national legal public holiday. Okay, it's a little confusing, but it's better than it used to be. By the way, the same language is now in the vacant land contract. Okay, so what does it mean? It means that other than acceptance of a contract, which can be on any day of the week, 365 days a year, and an effective date, same thing, can be on any day, 365 days a year. Okay, everything else, if it falls, when you calculate the time, okay, if it falls on a Saturday, Sunday, or a holiday, okay, moves to the next calendar day. So what are the things in the contract that we're talking about here that would be affected by this?
Due diligence.
The inspection period. What else?
Financing clause.
Escrow deposit, loan approval, closing, obviously. Okay. So anything else other than those two things? Okay. So when we're talking about acceptance, we're also talking about counteroffers, right? So acceptance, counteroffers, and effective date are outside of this provision, right? So you have to be aware of it when you're calculating time. And the biggest problem I see is usually on escrow deposits. That seems to be where the bigger issue is. Okay. Okay. Any questions? This one can trip you up. All right. So, okay. Next thing we're talking, Jeff touched on this a minute ago. Property maintenance condition, inspections, and examinations. So the first paragraph where you see property maintenance in this contract, it says Except for ordinary wear and tear and casualty loss, seller shall maintain the property, including but not limited to lawn, shrubbery, and pool in the condition existing as of the effective date, okay, of the contract. All right, so that's what this is talking about. All right, what's a casualty loss? Hurricane blows through and does a lot of damage.
Yeah.
That's a casualty loss. Yeah. Yeah. Okay. So it appears again. Okay. And it appears under the closing costs, fees and charges section. So it says, if prior to closing, seller is unable to meet the as-is maintenance requirement as required in the previous paragraph, okay, a sum equal to 125% of estimated costs to meet the as-is maintenance requirement shall be escrowed at closing. If actual costs to meet the as-is maintenance requirement exceed escrowed amount, the seller shall pay such actual costs. Any unused portion of the escrowed amounts shall be returned to the seller. Okay, so the seller has an obligation to maintain the property. And Jeff talked a little bit more in depth. He talked about anything that is damaged or requires repair prior to closing. Okay. Right. And he's right about that. So you have to make sure that the seller, when you're working with the seller, that they understand that they can't let that pool turn black. All right. That pool has to be maintained. The property has to be maintained. It can't be degraded. We had a situation about a month ago, broken window. And the seller was like, well, it's just cracked. Well, no, you have to replace it before closing, right? You have to maintain that property. Okay. Anybody have anything that they want to add to that? Okay. But your seller has to understand they do have an obligation to maintain that property in the condition that it was at the time that the offer was made.
For
Ruth?
that situation, I'm thinking of my house. We have a window that needs replaced. For example, like if, for example, I was selling it and it cracked, but it's in the bathroom and we're not replacing it until we redo the shower because it would mess up the tiles and it would be impossible to find matching tiles for it. So if something like that happened, that probably could cause some problems because it'd be a much bigger thing to fix. I mean, would another option possibly would you be able to pay the buyer a certain amount of money that they would be okay with it?
Sure. Sure. Yeah. We have a lot of property owners that are not here, right? They don't live here. These are secondary homes and they don't want to get involved in that because they're selling the home. So yes, you can negotiate. Buyer and seller can negotiate a credit of some kind or something like that to cover the repair if they can't actually get it fixed.
Okay. With that one, the repair I mean, a lot of it would be superficial.
Don't think
mean-
too deep, Teresa. If the
Okay.
window
No.
was cracked before they went under contract, it's being sold cracked. If it cracked after they went under contract,
Right.
we're contractually required to fix it. So
Right.
Okay.
don't worry about the other stuff right now.
Right. Right.
Okay,
And remember
alright.
this is an as-is contract. Okay.
Okay.
And the defining point here as to what the seller has to do, we're talking about after contract here. Okay, because we have a contract in place. So what we're saying is the seller has to maintain that property from the time we went under contract through closing. That's what we're talking about here. Okay, so,
Okay.
but yes, okay. They can always negotiate a credit or some kind of something to cover these things. Okay.
Okay.
Questions about how this works? Right.
Ruth, I got another question. I don't think you touched on it, but what about we show the property and it's all P-rock like they are, and then it's weeds free, and then at closing, there's yard is full of weeds and hasn't been maintained. Is that even something?
Yeah, well, it talks about including but not limited to lawn, shrubbery, and pool in the condition as affecting, as of the effective date. So weeds in the yard, and you got P-rock, does that include, could that be defined as the lawn? I suppose it could. Shrubbery and pool, I would say, you're talking about the property, you're talking about the structure, but I would say, yeah, I would think, I don't know, I would think that probably if it's overrun by weeds and the shrubbery's not taken care of and trimmed and the pool isn't, that's what we're talking about, I would think.
I have something to add to that as someone that owns a lawn care business. Yeah, that happens a lot with us when we have clients who are selling their home and they have us maintain the lawn right up until it sells, and then that's it. Then we kind of we stop services. So yeah, that makes a lot of sense to me as well.
Mhm. Okay. Anybody else? Okay. Okay, so the next one is the survey provision. We do talk about this once in a while. In the contract, there is a clause that talks about surveys, and it says at least 5 days prior to closing date, buyer may, at buyer's expense, have the real property surveyed and certified by a registered Florida surveyor. If seller has a survey covering the real property, a copy shall be furnished to the buyer and closing agent within 5 days after effective date. Okay. So if you don't use the Monroe County Writer, you have, and the seller, but who knows, right? The question is, who knows if the seller has a survey or not? The only person who knows that is the seller. Okay. So this is a warning to the seller that if you do have the survey, you've got to get it to the buyers within 5 days after effective date. Okay. If you don't, okay, can the buyer get out of the contract?
Probably.
They can. But it's always been interesting to me as how do you know if the seller has a survey? Okay, but you want to protect the seller here a little bit. So in the Monroe County Local Writer, which is why we tell you you have to use the Monroe County Local Writer when you're writing an offer, it says, it amends that provision and says failure to deliver the prior survey and or the prior title insurance policy shall not be considered a breach of contract by the seller and will not constitute grounds for cancellation of the contract by the buyer. Okay. So it cleans that up. Another reason why you should be using the Monroe County Local Writer. Questions about that? And we have the revised one is in dot loop now that added the FinCEN requirements. Okay, this one. Okay, this here we're going to talk about material defects and things like that. We're going to look a little bit differently at permits for a minute. Okay, so in the contract, it says under permits disclosure, except as may have been disclosed by the seller or buyer in a written disclosure. Well, in this state, you don't have to provide a seller's disclosure, correct? Okay, so, and typically a written disclosure would be that, a seller's disclosure. Seller does not know of any improvements made to the property which were made without required permits or made pursuant to permits which have not been properly closed or otherwise disposed of pursuant to section so-and-so. If seller identifies permits which have not been closed or improvements which were not permitted, then seller shall promptly deliver to buyer all plans, written documentations, and other information in seller's possession and knowledge, okay, which or control relating to the improvements of the property. All right. So on one hand, we're saying what? The seller is saying here does not know of any improvements made to the property, which were made without required permits, right? Okay. And then we're saying, well, if the seller identifies permits which have not been closed. So you've got two things going on here. One, the seller doesn't have any knowledge. And two, we're looking at if the seller knows that there are permits or improvements which were not permitted. So what is it that is being, what is the responsibility to the seller now to understand what they're agreeing to here, right? That one, they don't have knowledge, but if they do know of permits that are open, okay, they have the responsibility to deliver information to the buyer. Questions about that? Okay. You have to make the seller needs to understand the obligations when it comes to this. So now we have seller disclosure. Okay. Seller knows of no facts materially affecting the value of the real property, which are not readily observable and which have not been disclosed to the buyer. Except as provided for in the preceding sentence, seller extends and intends no warranty and makes no representation of any type, either express or implied, as to the physical condition or history of the property. This is why the state just put in place the flood disclosure. It's directly related to this issue. Okay. Because this became a big problem. We had property owners who knew they had flooding conditions. They may have received claims against, their insurance and so on, and it became a major issue. But this is exactly why the flood disclosure came to be. Okay. Anybody have any experience with this? Frank, Jeff, comments?
Everybody does their stuff. I don't have anything recent for you.
Okay. Jeff, you got anything?
This contract puts the onus on the buyer to close anything. I don't know if you're going to talk about the rider.
We are, yeah. Right. But the seller has to understand the implications to them with regard to material defects and things like that. Okay.
Actually, I do. I'll give you one quick one. So if you can go back to that slide, Ruth. So you see where it says not readily observable? That's a key phrase in the contract, which means it's not that it has a stain on the wall. If a buyer walks in and can see that, that's readily available, right? It's readily observable. So that's not what they're talking about, right? It's talking about the things you can't see. So quick example, I had a client of mine that bought a house with a pool. The pool started losing, after we closed on it, he noticed the pool was losing water and he had to keep putting water in it. He called a guy to come out and take a look at it, and the guy comes to the house and says, "Oh, I was just at this house like a month ago." And he says there's a main drain leak in there. I told the previous owner about it. So that's an area where that can come back at an owner, right? If they don't disclose those kind of problems, they're setting themselves up for a civil suit going forward on things like that. So always make sure that is there anything about this house that I can't see or you're aware of that someone wouldn't notice? You might want to put that on a seller's disclosure just to protect yourself, so that you did disclose it to the buyer prior to closing. That's all I got.
A recent case over in Tampa where it dealt with flooding. Okay. And it was interesting because the agent who was representing was representing the seller in the particular transaction that was being discussed had represented the seller as the buyer when they purchased the property. The neighbors had told the agent at that point in time that the property flooded on a regular basis. Okay, that there was king tide action and the neighborhood would fill up with water. Okay, which was really one of the reasons why the existing seller was selling the house. Okay, and the agent had knowledge. Now we have a new transaction that closes. Haven't had any flooding. The new buyer, the new owner, goes and tries to sue the prior owner because they find out from the neighbors not only did that owner know, but the agent knew. Okay, what is your responsibility as an agent if you do know that there is something that falls in this category? So in this particular case, not only was a suit placed against the prior owner, but also the real estate agent. So what is your obligation if you know?
Disclose.
Mm-hmm. Exactly. Exactly. Questions about any of this? Okay.
Ruth,
So
how would you disclose that? When the seller is not forthcoming, how do you as the agent?
I think that my own perspective is you have to make sure that the seller understands the obligation, and you're not going to put yourself in a position where you have a problem. So you are going to disclose it.
Yes.
That's your job.
Okay.
I
That's
would
your job.
disclose it when you show the property before you even get under contract.
Well, you're supposed to disclose it then,
Yes.
not afterwards.
No, it's
Okay.
before.
Right. I mean, you got a problem over in Big Pine, right? With the weed that decomposes, right? You got a problem over there that affects air conditioning units and so on, right, Chrissy?
Yes.
You got a
Yes.
problem over there. And for a long time, we used to have a disclosure that we gave everybody who was buying property or listing property in that area because of the impact to um, um, air conditioning units and so on, because of that problem. So, yeah, you have to disclose. So this gets to the next piece in the contract that talks about the seller's assistance and cooperation in closing out of building permits. Under this provision, it's the buyer's responsibility to close them out. The seller's obligation is to cooperate with that. Okay, so they're going to cooperate, they're going to provide information, documents, whatever else, but they're not required to expend or become obligated to expend any money. So the entire responsibility shifts to the buyer, unless you use the Monroe County local rider. Okay, and in this case, you have the option to shift the entire obligation to the seller, including the financial responsibility for it. Okay. But that's only if you check the box. So your contract here would be contingent on the seller taking care of these things and also satisfying any expenses attached to this. What is in here that a lot of people overlook is if these things are not closed prior to closing, the closing can be extended up to 15 days, and these are calendar days, for the seller to close the permit in code violation cases. Do you need an addendum for that 15-day extension? No, you don't, because it's built right in here to the Monroe County rider. Okay. And then if it's not closed by the end of those 15 days, then the buyer can cancel or accept the property with the open or expired permits or active code violations. Okay. So questions about any of that? Okay. Okay, so we're going to talk about flood zones. This is an interesting provision in the contract. It's flood zone elevation certification. So the buyer is advised to verify by elevation certificate which flood zone the property is in, whether flood insurance is required by the lender, and what restrictions apply to improving the property and rebuilding in the event of casualty. Okay, so let's just stop there for a minute. So looking at this, what is our responsibility with regard to this? Okay, everybody's quiet. Our responsibility is to, when we take a listing or we write an offer, to do our due diligence. Frank and Jeff and I talk to you about this all the time. You have to know your property. Right? It's something that when we had Patrick Stevens work with us, he kept talking about it over and over. You have to know your property. So what do you have to know? You have to know the flood zone that it's in. If there's a downstairs enclosure, you need to understand what that means. Okay, so we have to know as much about this property as we possibly can. The flood zone, we should get an elevation certificate if we can. And then you've got to understand, if you've got a downstairs enclosure, what is the status of that downstairs enclosure? That's number one. Okay, but this goes on. This goes a little bit further. Okay, so if the property is in a special flood hazard area or a Coastal Barrier Resource Act designated area or otherwise protected area, okay, which is identified by U.S. Fish and Wildlife, and the lowest floor elevation for the building and our flood insurance rating process is minimum flood elevation. This only applies to properties that are determined to be ineligible for flood insurance because they are protected through the Coastal Barrier Act, or through Fish and Wildlife. This is not your average everyday property in the Keys. There are certain areas in the Keys where this applies. There's a couple in the lower Keys where they are in the coastal. We're all in coastal barrier, but there are some that are actually designated as ineligible for flood insurance. Has nothing to do with the structure, has to do with the designation by FEMA for that particular property or properties. Okay, they're very, very few.
Isn't that isn't that like a lot of properties that have substantial mangroves and stuff like that? Would that be right, Ruth?
Yeah, some of them are. Yeah, some of them are, Frank. There's some in the lower Keys. I'm trying to think if it's Big Torch that has an area where, and they're few and far between, where they actually, it has mangrove, it has other growth, it has other things, and there's a whole list of things that determine, how a property is identified. But they're very, very few, but they're there. So you may never run across them ever. You may not. But if you do, then this clause kicks in. But what I want people to understand is I've had a few people over time say they misinterpret this because it goes on to say buyer may terminate this contract by delivering written notice to the seller within 20 days after effective date, and buyer will be refunded the deposit and released. This, and I've had this a few times where the agent didn't understand that this was a rarely used term. This does not apply to the buyer finds out what the cost of their insurance is going to be within 20 days after effective date and decides I can't afford it, I'm not moving forward. That's not what this is about, but I've had that 2 or 3 times where this is totally misunderstood by both the agent and by the buyer. Okay, this is dedicated to specific properties where the potential buyer is going to try to work through and understand what the situation was with the property. They've got 20 days to do that. Okay.
I'll add a quick little bit of trivia in here for you guys. So just so you know, and if you ever come across the situation at Florida Fish and Wildlife, you understand that they are essentially state troopers, right? But they are the only preservation enforcement agency in the United States that carries both state and federal authority and enforcement. So they are the only ones that can enforce and have a federal authority. So they can act in both on both sides of that law. So when they come, they have the right to come in and check your seawall, see what you're doing. They patrol the canals. They can do the exact same thing that U.S. Fish and Wildlife have, and they have the ability to charge on a federal level. So just something, a little trivia for you in case that ever comes up in conversation.
Well, Frank. No, but just so you know, that's what this pertains to. But in the first part of this, once again, this gets to, we have to know everything we possibly can about any property that we're dealing with, regardless of which side we're on. That's why it's so important for you to do that research before you take the listing and before you write an offer. Okay. So I feel like I'm preaching to the choir with that, but okay. The next thing that we have in the contract, little known, I'm sure you may have glanced at it. There's a little thing in there called the energy brochure. Okay. The buyer acknowledges receipt of Florida energy efficiency rating information brochure and as required by Florida statute. How many of you have ever provided the energy brochure to anybody? Frank is raising his hand. Jeff
Never.
is not moving.
Never. Not one
never.
time.
Always.
Not one time, right?
Always.
Okay. Did you just say always? Okay.
I have always, since the beginning I got into real estate, I have always provided it.
Okay. since I'm not hearing anything from the agents, I'm assuming that not too many people either know that's in the contract or have ever provided it. So what does it mean overall? Can the buyer terminate the contract? Okay, because it wasn't given to them. No, they cannot. It's not an automatic right to cancel, right?
Do we
It
even have an
is-
energy brochure?
We do.
Then
I have to be,
yep,
it's there, I think. If not, I'll be checking it right after this.
no, it's
Uh,
there for sure.
Okay, so it's not an automatic right to cancel. Why? Because it's an informational brochure. It is not a contingency. It's nothing like that. There is no actual contractual right to terminate based on not receiving this. Okay. All right. So it is a statutory disclosure requirement, but it is informational as far as the contract itself is concerned. Okay. So the other one I want to talk about is lead-based paint. You're all familiar with this. Okay. But you have to remember, if you've got, it only applies to residential properties that were built before 1978, okay? It is a federal requirement. You have to have it completed for a contract. You just go into the addenda section of the contract, you check off the box, and you get it taken care of, okay? It is required by federal law, all right? Is it required for the contract to be valid? Yes. It is. And the disclosure must be signed by all parties, and it has to be attached to the contract. What do I mean by attached? You check off the box on addenda. Okay. Failure to include it can result in civil penalties, fines, and legal liability. Okay, so you have to have it. So that gets me to when you have a contract and you have various addenda that are required, lead-based paint, condo rider, HOA disclosure, whatever it is, Monroe County local rider, and you don't get it back. You get your contract signed, it comes back. All right, you're the listing agent and it comes back, but it's missing one of the addenda that you've checked off on the box. Do you have a contract at that point? Do you have an effective date?
No.
No, you don't have an effective date. You don't have a contract until the last piece is received, and it will be, is it the date that it was signed by both parties, or is it the date that you received it? It's the date you received it, that it was delivered to you. So you got to be very careful. So you have to, when you get things back, you have to go through them and make sure it's complete, that you've gotten every document and that they're all signed the way they're supposed to be. Okay. Okay, let's talk about FIRPTA. FIRPTA is in the contract. It's actually in two places. I'm not going to go into item V because that's a very long explanation about how FIRPTA works in terms of filing with the IRS and so on. It is an IRS provision that pertains to sellers who are designated as a foreign person. Okay. And that definition, if you want to go look at it, is in the Foreign Investment Real Property Tax Act. Okay. It is the responsibility of the closing agent to handle this. Okay. So the seller shall inform the buyer in writing if the seller is a foreign person as defined by the Tax Act. Buyer and seller shall comply with FIRPTA, which may require the seller to provide additional cash at closing. It's a tax. Okay. The IRS is going to tax them. I don't know what the scale is now. If the seller is not a foreign person, the seller can provide buyer at or prior to closing a certification. Again, but this is all handled by the closing agent. Okay. The buyer, it's just a notification to the buyer. The buyer really doesn't have any role in this. Okay. If you go to item V in the contract, again, you can go through it. There's a lot of detail about how it actually works. But again, this is an issue with the seller, and it's the closing agent is the one who has to deal with this, not us. Okay. All right. Next thing is the 1031 exchange. We see a lot of these. Okay. So a 1031 exchange is also a tax issue. It's a strategy that allows real estate investor to sell an investment property and defer paying capital gains taxes by reinvesting the proceeds into another like-kind property. Okay. So we have the 1031 exchange in the contract, just like we have FIRPTA. There are also addendas that you can add to the contract that deal with FIRPTA and with 1031 exchange. There are those who say, well, we already have it in the contract, you don't need the addenda. It is up to you. Okay. If you want to use it or not use it. So if either seller or buyer wish to enter into a like-kind exchange, either simultaneously with closing or deferred, okay, which I've seen that happen a couple of times. The other parties shall cooperate in all reasonable respects to effectuate the exchange, including execution of documents, provided, however, cooperating parties shall incur no liability or expense related to the exchange. So there is no expense incurred in this transaction to facilitate the compliance with 1031 exchange, okay? And the closing will not be contingent upon or extended or delayed by such exchange, okay? Unless parties agree and there is an addendum that changes the closing date. Okay.
Ruth, can you just go back on that one? So there's no, you mentioned a 1031 exchange addendum. So what if they don't even know? I mean, can you just talk about that for one more quick second? Like, what if they don't know that they're going to do that? Or does that have to be included if the seller knows that they're using a 1031, that they're going to go into that?
You're talking about the seller is going to have a 1031 for a reinvestment, or the buyer is going to have a 1031?
I've got a seller who's going to, if we can ever get it sold, put that money into a 1031 exchange. So there's an addendum that I need to use upon?
No, not for the seller.
Not for the seller, but for the buyer.
No, for the buyer.
Okay.
For the buyer. It does exist. But I've had different opinions from different attorneys that we work with that say, well, you don't really need to use the addenda because it's stated here in the contract what the responsibilities are of both parties. It's just that the buyer has to identify that there is a 1031 exchange, and that has to be identified to the closing agent.
Okay.
Because it's the closing agent that's going to actually deal with it, just like FinCEN is another one. But you have to be mindful. And we have an agent right now that is dealing with a very complicated 1031 exchange on the sale of farmland. All right. So, and it's a sale of farmland, plus there is financing involved in the transaction as well. So the thing you do need to know is this is a 30,000-foot view of this. Okay. Not a lot of details, but the way it works is, the first, that you have to understand what the deadlines are for your client if you're representing the buyer, okay? There is a 45-day rule that the buyer has to identify a replacement property within 45 days of closing of the transaction that the money is coming from and is going to go into a 1031 exchange, okay? Simultaneously, there's a 180-day rule to close on the replacement property within 180 days. And that's of closing of the property. All right. So you need to, if you've got a buyer that's working with a 1031 exchange, you need to have a really good conversation with them so everybody's on the same page with regard to the timing. Okay. And making sure that the deal you're working is within that time frame. Because if they miss either deadline, they're going to have to pay the capital gains tax, because that's what this is about. Okay, it's about avoiding capital gains on the first property that closes. So the other thing is, when they close on that initial property, those funds go to an intermediary. Okay, it's a 1031 exchange company. They hold the money. Okay, your buyer never touches that money. Okay, it goes to a third party. Okay, if they do somehow get access to that money, then the exchange is disqualified. Okay. So very high level view, what's a like kind requirement? It's very broad in real estate. So you can exchange a condo for a commercial building, land for a rental home, multifamily for retail. Okay, I don't want to get into the details of that. I'm not an expert in it. So if it's something that we want to explore, maybe that's something we could do in a sales meeting or something like that. If there's enough interest to get a little more meat in this. Frank, Jeff, do you have anything to add to it?
The only thing I would say is, you're not a tax expert, and if your buyer wants to do a 1031, I would recommend that they immediately speak to a 1031 exchange intermediary. And I would let that expert do the heavy lifting on the deadlines and dates and make that work. So,
Yeah, the one we have now got more complicated because the property that is going to be subject to the 1031, not only is it farmland in Maryland, it was being sold at auction. So it kind of complicated things. And then when our buyer decided they want to move ahead, they wanted to make an offer, we had to get the contract for the farmland to see what the provisions were for closing because it was being handled through an auction company. So it ended up looking at a lot of contracts and talking to attorneys to figure out in our contract, what were we going to do about closings, inspections, and so on, because it was going to be protracted. And a lot of it was going to be based on what was in that contract for that farmland. So it's an interesting contract and it was fun to work on, but you just have to know, is there a 1031 exchange involved and what dates are we really working with? Okay, so the date you really want to be concerned about is the 180-day date. Okay, but it's up to the buyer to manage the process and the closing agent. Okay, questions about that? You will run into this. Okay.
Ruth,
Okay.
I have one just tiny piece of information on this. I did a 1031 purchase from someone who was a foreign national, and the deliberations, the problems that seller had, it is a great thing that they weren't trying to do an exchange of any kind, because the sale would never have gotten to happen.
Yeah, that
It
had
took
to have
them
been
2 years to
interesting.
get their money from
Really?
the government. So
That's interesting.
yeah, it was.
One last point, because it's 10 o'clock and we have a lot more to cover, and I can actually stop at some point and I can go use what is left in here in the next session that we have. But just remember, irrespective of what's going on with the 1031 exchange, you've got a contract, all right? And the buyer and seller have to perform regardless of what's going on with the 1031 exchange, okay? So that contract is in place and both parties have to perform. Okay, any other questions about that before we move on? No? Okay. This one, access to property to conduct appraisals, inspections, and walkthrough inspections. Seller shall, upon reasonable notice, provide utility service and access. We just had one last week where the seller turned off all of the utilities prior to the walkthrough. Okay, so the seller has to provide, upon reasonable notice, utility service and access to the property for appraisals, inspections, including the walkthrough or follow-up walkthrough if necessary prior to closing. So make sure, if you're representing the seller, that they understand their obligation to do that. Okay. All right, so we get to walkthrough inspections. This is something that we don't really talk about, but can be very problematic. So what it says in the contract, everybody knows what a walkthrough inspection is, because we have a couple of new agents here with us this morning. One of them is shaking her head going, yes, I know. Okay. All right. All right. So on the day prior to closing or on closing date prior to time of closing, as specified by the buyer. Okay. It's not the seller's choice. It's the buyer's choice. Buyer or buyer's representative may perform a walkthrough and follow-up walkthrough if necessary. A follow-up walkthrough is they found something in the walkthrough that needed attention, maybe a repair or something else, and then we're going to have that taken care of, and then we're going to do another walkthrough. Okay. Inspection of the property solely to confirm that all items of personal property are on the property, which we talked about before, and to verify that seller has maintained the property, as we talked about before, as required by the as-is maintenance requirement and has met all other contractual obligations. So this means, so now you're at the walkthrough, so now you can see the importance of making sure you have very specifically identified what is conveying with the property, what's not conveying with the property, as Dave brought up, again, verifying that the seller has indeed maintained the property as it was at the time that the offer was presented. So the pool is not black, it's not, the yard is not overgrown, and so on. So walkthrough is very important, but it has to be conducted properly. Okay, so what are the key points? The seller is required to leave the utilities on. Agents cannot conduct the walkthrough inspection as the buyer's representative. Okay, and I've had this over and over again where the buyer is not here, so the agent has taken the responsibility of conducting the walkthrough themselves. That opens you up and opens up the brokerage to an incredible amount of liability. Okay, you are not an inspector. It's outside of your license. So you're outside of your lane. All right. And you can incur liability, and you can also, the brokerage can incur liability for you taking on that role. So what's the best way to do a walkthrough?
Ruth, we could do a virtual walkthrough, a FaceTime with them, right?
Yeah, we're going to get to that, Trish.
Okay.
Absolutely. Okay. All right. So your job is to facilitate the walkthrough, right? To make sure we have access to the property and to be there to walk through the property, hopefully with your buyer or their representative. So if the buyer can't be there, can they send a family member? Can they send a friend to act in their place? If not, as Trish just said, you can do a live video with your buyer, FaceTime, Zoom, and have the buyer direct you as you walk through the property. Okay, direct you as to what they want to see, where they want to go. Okay, so they're directing you, but they're directing you in real time. Okay, let the buyer ask the questions, not you. Have them directing you as to what they want to see, what their concerns are. Okay. Anybody want to tell us how they conduct their walkthroughs? Okay, I had a situation where one of my agents, great customer service, buyer couldn't be there, handled the walkthrough. Okay, didn't bother to open up a cabinet door under the kitchen sink. Okay, if they had, they would have seen that there was a consistent drip under the sink. Okay, that wasn't there before when the home inspection was done. As a result, we had mold starting, to form, and there was an issue. Buyer closes on the property, and now we've got a mold issue in the house. Who's responsible for that? Yeah. It was the agent. And in turn, it was Coldwell Banker Schmidt. Okay. So there's a lot of liability that can happen here. So the moment you give advice, all right. Oh, I'm sorry, we're going on to the next one. Okay, sorry about that. Any other points that anybody wants to make about walkthroughs? Jeff, Frank, you have anything in particular you want to say about that?
My recommendation would be, in lieu of doing a virtual walkthrough, to hire whoever did the buyer's inspection to come back and re-inspect it and do the walkthrough. Get them to pay an inspector to do the walkthrough.
Yeah, that's a good idea. It's a good idea. But whatever you do, don't you act as the representative for the buyer. Okay. Okay. Next, professional liability here. All right. So this is actually in the contract as well. So the minute that you give any kind of advice, outside of your license, you increase liability, right? For yourself and for the company. So why does it matter? All right. You're expected to provide factual information and facilitate transactions. You're not expected to give legal advice, tax advice, engineering, inspection opinions, construction opinions. But how many times are all of you asked a question by your buyer? What do you think about? Can I do this? You know, what is what are my property taxes going to look like? How many times do you get these kinds of questions? Probably every day. Okay. And how do you answer them?
For the tax question, there is a way to do that through the tax office and just have them, either you do or your buyer does, contact the tax office and say, what will the taxes be? And they give you a range, usually not an actual number. But that is how you do the tax part.
You have to be very careful because your license doesn't extend to things like that. So what happens if you give advice and the client relies on the advice that you gave them for something that's outside of the parameters of our license and the client suffers a loss? Okay. Are you going to get sued?
Well, I usually have whatever the tax office says, them send me as an email and I provide that to the buyer.
Mm-hmm. Good idea. Okay. So you got to be very careful about giving opinions, giving advice. And if your client acts on the advice that you gave them and it was wrong, okay, you're setting yourself up for a lot of liability. Okay. My favorite one is that permit isn't an issue. That's my favorite one. So,
Ruth,
yeah.
there's actually a tax calculator feature on the
Mhm.
Monroe County Tax Collector's website.
hmm
That's where I send people. You just put the purchase price in and it calculates the estimated property taxes. And I let the buyer go there and do it.
Is a very good point because I've used that calculator a few times. But whatever you do, and I've overheard agents do it all the time. Well, the current property taxes are this, so if you go, add X percentage. Well, wait a minute, it's not quite that simple. Property taxes, is this property going to be subject to homestead? Is it not going to be subject to homestead? Don't get yourself into it. Stay out of it. Okay. And Dave is absolutely right. Best way to handle it. Same thing with opinions on anything with regard to spalling. That's another one that I hear agents give their opinions on spalling and what spalling is going to cost. Don't give your opinion on that. Get an estimate as to what it's going to be. Stay away from that one. Okay. If you don't know what the status of a downstairs enclosure is and what can happen to that downstairs enclosure, should there be damage? If you don't know, then you get them to the people who do know. So you get them to the building department and you get the building department to tell them, but you should have already done it before you wrote an offer or took a listing. You should have already talked to the building department to understand what's there, but you direct them to the building department. Okay. If you don't know, don't guess. Because that's another one. Two big things that trip people up: spalling, downstairs enclosures. Okay, so this talks about, it's in the contract, and I just abbreviated a little bit. So basically what it is, it's telling buyer and seller, buyer agrees to rely solely on the seller, professional inspectors and government facilities, not us, with regard to information and facts that materially affect the property value. Okay, so we're going back again to that whole issue of material defects. Okay. I know, we all say customer service, but you got to be careful with customer service there, as opposed to starting to give advice. Okay. Okay. This one we can just touch on because we're running late. There's something in here called waiver. It's paragraph Q. Probably nobody's ever read it. Anybody actually pay attention to this? Okay, well, we'll just take a quick look at it today. What it says is, failure of buyer or seller to insist on compliance with or strict performance of any provision of this contract or take advantage of any right under this contract shall not constitute a waiver or other provision. So what does that really mean? Okay. It means if a party chooses not to enforce a right at one time, it doesn't permanently give up that right unless done in writing. So it's a little bit confusing. Simply, just because you let something slide once, it doesn't mean that your client has given up their rights forever in the contract. So what are we talking about? So just a quick example, if the buyer delivers a document late and the seller accepts it and we move forward, it doesn't mean that the seller did not automatically waive all future timing and rights. Okay, so it gives a little bit of a grace if there are things that are missed, but you don't give up your rights for future issues within the contract. But it's not a good way to act. It's not a good way to manage a contract. So a true waiver typically requires it to be in writing. So what are we talking about? We're talking about inspection periods. We're talking about a receipt of documents and so on. But it's not a habit that you want your clients to get into. They have to comply with the contract. And even if the parties, and then what can happen is you let something slide, it did say in the contract that the lease was due within 5 days of effective date. And we didn't get it, but we're not going to enforce the contract. We're going to let it slide. Those are the things we're talking about. Okay. It's okay. The seller's not upset about it. But that can't be a habit in the contract. Okay. And if there is an issue, and it goes to litigation and you see habitual action within the contract, the parties, constantly are not complying. And the court can then say, okay, we think you gave up your right, okay? Because there's no objection from the other party that you didn't perform. They just kind of overlooked it. And by overlooking that, it can be construed that you gave up your right. But this is where you get into trouble. Why do you get into trouble? Because you let things slide. You have to always track and communicate what is required in the contract. You as the agent are responsible to track deadlines, remind clients of their consequences if they miss a deadline, okay? Things that can involve what? Escrows, okay? Buyer can end up in default, seller can claim an escrow. Encourage decisions before rights expire, all right? If you are not working with your clients and you're not explaining what their responsibilities are in the contract, if you're not tracking those deadlines, if they don't understand when they have to perform, that's on you. Okay. It's your responsibility. So now you could end up with a negligence claim. Okay. Because you did not inform your client. So failure to document is your liability. All right. So if you don't document issues, you don't send objections, if you allow verbal agreements, then you can create disputes between the parties and exposure for yourself. One of the big things, I was reading another article about this the other day, texting. Texting back and forth between agents to solve problems, not a good idea, right? Because that can get you into a lot of trouble. All right, so the best thing you can do is track all your deadlines, document all your issues immediately. Don't rely on verbal agreements or texts. Do not interpret waiver legally and encourage written decisions. Avoid just move forward advice, which is, this didn't get done. We didn't get this, whatever we needed in the contract, but we'll just move forward. It's okay. Don't ever do that. And I think that's it for me. Questions about anything that we covered today? You're also quiet. Jeff, anything to add?
I would just say you guys get paid a lot of money to do paperwork and become a student of the contract. Anytime you read it, you get, it's like reading the Bible. You read it 5 times, and every time you read it, you learn something else. So just keep learning and reading.
Absolutely. And that includes things like the Monroe County Local Rider, some of these other things One of them today is the condo rider. It's a little more complicated than it used to be because it's looking to provide more information. You just need to understand what that is. But our goal here, Frank, Jeff, myself, and Brian, our objective here is to make you experts in this because your competition clearly is not. Okay. You are the best trained agents in the Keys. And we want you all to really be expert in your field. And by doing so, that's going to what? Enhance your reputation, build your business, but more importantly, it's going to protect your clients and yourselves. So we are always available to answer your questions, the three of us. So don't hesitate. Don't do something where you're not sure. Call one of us. One of us is always available. So, Frank, anything to add? Did we lose Frank? We may have lost Frank. Okay,
I have a quick question if we have a minute.
sure.
So a couple of things that I was always taught was when I was putting a listing into the MLS in the comment sections for the agents to write buyers and buyers agents to verify all of the information. Necessary, helpful, not necessary. How would you say?
I like that. I've always liked that. That it's incumbent on the buyer's agent to verify all information. I have always liked that. Some agents do it. I don't see a lot of it anymore, but it's something that I think is a very good idea.
Does it protect me as an agent or my seller?
It could. I don't know, Jeff. What do you think? Could it protect her?
I think over disclosure is always better than under.
Sure.
I won't particularly, feel one way or the other about that particular thing, but if it makes you feel better, put it in.
Got it.
I mean, it's not, that's not gonna keep you out of issues more than likely. I mean, I believe that if you get into a litigious process, the judge is going to look at what's in the contract, right?
Sure.
They don't care about the MLS. I think
Nope.
there's even a clause in the MLS that says, don't rely on any of this information for anything. So,
Sure.
that's up to you. If that's your standard of practice, then put it in. And if you guys all want to put that in, put it in. It's, but
Good reminder, to other agents. But as Jeff said, and one of the things Brian will always tell you is, and when people in other companies or people you're dealing with complain because you're sending them all kinds of disclosures, right? We're sending them all kinds of disclosures and things like that. We do that for a reason. We have lots of disclosures. We have general information. So we've got buyers for property sales disclosures. We have all kinds of things, right? Buyer's inspection disclosure. They're there for a reason. Because as Jeff said, our job is to know our properties and disclose. And that is the greatest service you can provide to your clients, but also to protect yourself and the company. That's why we require, it's not a lot of research, but we want you to know the property. I can't stress it enough. And that's one of the things we're going to talk about in one of these next sessions.
dot loop is your friend. Do everything
Yes.
in dot loop because that's your audit trail. And if you get in a wrinkle and we get subpoenaed to supply things, it's proof that we've delivered what we are required to deliver as long as you
Exactly.
deliver it.
Right. And then that
There's
gets
an
me
activity
to
log. There's an activity log in dot loop that
Mhm.
shows everything that anybody ever does in the loop, right?
Mhm. Right from the date the day that loop is created. And it, again, like Jeff says, it shows everything. And unfortunately, Jeff and Frank and I have to go in there frequently to do an audit. And Dotloop will tell you, it provides an audit trail for us. And we're able to go in there and we're able to look at who shared what with whom. Did they view it? Did they sign it? Whatever was going on. All right. So we do it all the time. unfortunately. I do it all the time when I'm just looking at transactions. And then that's the importance. That's why I tell you dot loop files are the official files for the company. And then when we do get into litigation, that's where we all go. And that's why they have to be complete. That's why we have to disclose. That's why you have to do permit history. You have to do flood zones. You have to do look at tax bills and so on. You have to have all that. And when you don't have it and you're not sharing it with people in the transaction, that's where we get in trouble. So
The
I won't preach
easiest
it.
thing to do is to say what needs to be said today, so you don't have to try and remember what you said yesterday. Don't just be upfront. It's not
Yeah.
that hard, you know, don't let fear of loss control your thought.
Thank you, Frank. And on that note, anybody else? Otherwise, we'll finish up. And if you have any questions about it, these slides will go back at you, and then Frank has the recording. He'll put that out on YouTube. Call me if you think of something later, or get a hold of Jeff, get hold of Frank, and we're happy to answer your questions. Okay. Well, thank you all.
Thank you,
And,
guys.
Thank you, Ruth.
Thank you.
okay, we'll see you soon. Take care.
All right. Bye-bye, guys.